Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. I'm Melissa Gregg. I'm a financial mediator and business valuation expert in St. Louis, Missouri. And today I'm speaking again with Kelly Lise Murray. She's a lawyer, professor, legal scholar, Stanford and Harvard law grad, former Vanderbilt Law faculty for 18 years, and host of Wealth Litigated podcast. So we have already shot a video about a really complex case, and we told you that we would be doing this series on case law. So today we have another case in the series, which kind of starts to show the full spectrum of what can happen when valuation evidence is strong, when it's weak, and when it's completely missing. So the first case that we're talking about is Clark v. Clark from South Carolina. And again, a lot of it's about evidence, testimony, what makes a valuation stand up in court, what makes it collapse. And Kelly is a pro at talking about these cases. So welcome back, Kelly. How are you doing today?
Hi, Melissa. I'm doing well. How are you?
Good. So, I mean, this is an interesting case. Like, whenever I was looking at it, it's almost like textbook the things that we need to be aware of, the ways that we can think that theory is just like a given, right? Discounts are a given. But it wasn't that simple. So maybe you could give us kind of a background of what Clark v. Clark was, and then we'll go into like discussion about all the nice points that it clearly delineates for experts.
Well, this case went all the way up to the South Carolina Supreme Court on the issue of whether marketability cannot be included as a discount. Trial court used marketability, relied on one of the spouse's experts who used a marketability discount. Appellate court reversed and said, nope, you cannot use marketability. That went up to the Supreme Court. So the ultimate ruling in the Supreme Court is marketability is discretionary for the trial court because of the uniqueness of valuing a business in a divorce. So that's the legal framework, but the factual framework is even more interesting. This is a business founded by the husband's father in the 1980s, and it's a North Carolina mill business. And just because it's a North Carolina mill business doesn't mean they're all the same. That's another issue in this case. In terms of one of the experts using comparables, was that expert comparing apples to apples, or was it apples to oranges, even under that broader category of a mill business? This was a 25-year marriage. They had 3 children. And then we get to the soap opera facts. You should read the opinion because there's so much going on that's relevant to the business issues. Normally, these soap opera facts wouldn't relate to the business, but how the husband ended up owning 100% of his father's business is absolutely part of the factual saga. So his family, it's the husband's family that is all of the drama. His mother passes away. His father then is diagnosed with a terminal illness. His brother goes missing, and it turns out his sister's husband is ultimately charged with manslaughter, and she's charged with an accessory to the manslaughter. So the husband ends up buying 25% interest of the business from his sister for an amount, and that would be a marital interest, but he inherits as a gift from his father 75% of the business, and that is separate property. So the battle over the business and its valuation is over a 25% share. That's really what gets us started into the valuation battle.
Yeah, and, and it's interesting because, again, both of these sides brought experts, right? And so, and the big picture was we have discounts, we have some is gifted, so it's a separate asset, some is marital. But even at a 25% share, that's what we're looking at as the marital portion, this was still owned in total by this one individual, right?
Yes.
So, but we're valuing the 25%, and implicit in that in valuation theory is there's always going to be a discount for lack of marketability for any ownership, right? And so it's just in valuation world, it's just a given. Like, and then it's the quantification of it, which is subjective, which I think the court has clearly always seen as like, are you just making up whatever number you want? Like, how are you backing this up? But it also, maybe you could talk to us a little bit about like what the first expert did, and we can dissect it a little bit.
The number just that we start with is what the husband was paying the sister over 14 years. The husband buys the sister's 25% share for $400,000 over 14 years. And if you're the other spouse, you're thinking, I get 200,000, right? He's paying her 400,000. That's quantified. That's an actual transaction. He's obligated to pay it. And that's not what she ends up getting. And so that's where we need to get to. The husband's expert, which is the approach that the courts actually relied on, used 3 valuation approaches of this 25% share interest: an asset approach that included a lack of control discount, a market approach, and an income approach. The wife's expert agreed with the marketability discount and then changed the testimony. And that made a huge difference on appeal. Well, it made a huge difference at the trial level, but it also made a huge difference on appeal, because when the wife's expert had included a marketability discount and then backtracks, that's the word the court uses. That says the wife's expert backtracked. And there you can just, even without reading the opinion, you know what happened to the courts. The credibility given to that wife's expert, it just plummeted because of the tracking.
Some of it makes sense because, again, you had an actual transaction that happened, an actual purchase, but the purchase was still like like a related party transaction, So, and for the most part, where we see all of these issues in a court system, that it would go to court, that it would go to appeal, that it would go to the Supreme Court, is the gray area. So if there's a gray area, so yes, there was a purchase that went into play. And I would also say, okay, support it with some market data, right? And say that that was reasonable. But the market data across the board, and I typically use it as a sanity check. And the reason why I say the market data is a sanity check is because you can literally go through every single transaction and say, well, how is this not like your company? How is this not like your company? A lot easier than how is it similar to your company? So I'm always trying to head that off in testimony by saying, well, it's a sanity check. It verified that that internal transaction was realistic, but that's not what happened here. And the backtracking is a serious issue. Now, how did they backtrack? Did she actually testify, or were there 2 reports? Did she issue a report and there was a draft and then she changed it? Or do you recall?
I don't have because we're dealing with appellate decisions, we don't have all of the specificity of that, but it was documented that the testimony changed. So what probably happened is the report had the discount and the testimony at trial backtracked.
Yeah.
And the opinion also elicits that it was at the direction of the wife's lawyer. So that actually comes out. And that's something I want to ask you about. Retaining a business valuation expert early by the attorney lets you have discussions and strategies before any reports are issued. And couldn't this whole backtracking be avoided by getting the valuation expert in early and really buttoning it down? Would that be helpful?
Yeah. And I think that, from my experience in kind of testifying around the country, it seems like every state is a little bit different. Like sometimes you're protected if you're hired by the attorney, sometimes you're not protected. So for me, I like to protect myself by not issuing a report until I've reviewed it online in Zoom with everybody, by not issuing drafts of the report so that they're sitting out there in case things change. But at the end of the day, what you're really getting at is, if you provide a valuation and that marketability discounts and discounts for lack of control are always relevant for a 25% interest, the moment that you decide that you're not going to do that, right, is really going against what theoretically is sound. And if you don't have a good logic or reason to back it up, you're going to be crossed on that and be
Absolutely.
like, well, every other valuation, did you apply a discount? Yes. They're going to pull up, nowadays, they're going to go on a listserv and be like, hey, has anybody used Melissa and she hasn't used a discount for like, could you send me that report? Like, attorneys do some kind of legwork in this to get you on the stand or get you in deposition, and they probably would have identified it in deposition whenever they got. So I prefer to never have a draft. I prefer to just have go straight to final report or issue nothing in the interim until, because these cases, it could take a year. Like I could have valued it as 12/31/2024, but now we're in 2026 and I got to update it to 2025. I'd rather not have this comparison. If they start to compare, well, you did a different cap rate, oh, you averaged these different, like, I don't want to have it sitting out there. So I think, yes, hire the expert, but from an expert perspective, protect yourself. And even when the attorneys or the clients say, I'd really like to see a copy of it, like I need to, kind of look at it and dissect it. I don't mind sitting on a Zoom for quite a long time, right? I don't mind sitting there while I've even had them read full federal reports online while we sit there, and we, like I let them sometimes control it. Like, hey, I'll be back in a half an hour. Take a look at this. But the moment you put it in email and you save it and you do all of these things, I think you're just setting yourself up. And so I think it's a protection that I put in place, even when the lawyer's like, oh, this is work product, or, oh, this is protected by the attorney. That's not always the case. And I'm going to have to release it if I get subpoenaed. And because that's my credibility, that's my way of operating, right?
Well, Melissa, what you just described, protecting the integrity of the process you follow as a business valuator, you're also protecting the client and the lawyer at the same time, and in some ways from themselves. It is a total protection. It's fantastic advice given what we're seeing in this one case, and we could pull up other cases and confirm that. This case shows what happens when the expert backtracks for whatever reason and doesn't have a better reason other than the lawyer asked me to. It's a really bad reason to have to admit, either in a deposition or on the stand in front of the judge. Two very bad places to say that. And that's why it's so important to look at how this litigates. It's one thing to say, this is what you should do, until you show other business valuators how it plays out and how it can harm their ongoing reputation, in addition to harming the client and the lawyer in a particular case, it may not sink in. So this case confirms that backtracking is bad. You lose credibility, and it will impact the business valuator going forward for all the reasons you described, because it's even easier. AI did not help lawyers get access to previous reports. That's already been available for years through the legal databases. You can see where someone's testified and you can pull those reports. Yeah. So yes, it's just easier now, but it's always been available. And then that's the first thing any experienced litigator would do with an opposing expert. You would look at previous valuations of similar businesses.
Well, and you also have to understand, like, is there a plausible reason? Because at the end of the day, like, one thing that you really know well is appeals. And in all these situations, typically an appeal is like if the judge just went off the beaten path, right? So if you're an expert and you're providing valid documentation, evidence, like all of this compelling, because the discount for lack of marketability or control are subjective. There's really been no clear way to delineate it. It's still pieces of it, like you can quote reports, you can quote case law, but at the end of the day, it's very specific. And so in my mind, everything that you provide as credibility as an expert, like, yes, I looked at the 3 different ways to approach it. Yes, I provided documentation. Yes, I understand. Now you could value it lower, but at the end of the day, the judge is looking at, were you a compelling witness? And then the other side. So even by changing it, regardless of whether it was right or not, do you have a compelling reason? And if you don't have a compelling reason, you're just going to rock your own credibility. And at the end of the day, you're exactly right. Lawyers and clients, this is like their one time. They're going to be like, come on, Melissa, can't you make it higher? Can't you make it lower? And quite frankly, the reason why I present the value before I put it in writing is so that they could say, you know what? I don't want that to see the light of day. I want to go find somebody else before we even produce it because, and again, this is after 20 plus years of doing this. But at the beginning, when I was a newer expert, I would be like, well, okay, maybe I was wrong about that. Maybe okay, like no one will find out. I'll just do. And my predecessors, they would state a position in one case and go the next day to another court in another county, but things were not online then. Like you couldn't figure it out as quickly. You couldn't catch them per se. But I think that this stuff does follow you as an expert. You also have to realize those lawyers talk. And so if you capitulate to a lawyer, they're probably only going to use you for that case because now they know you would do that. And gosh forbid you are on the other side of them, they're going to probably pull it back up against you and say, well, she changed her opinion whenever she was on a case with me. Why wouldn't she do it for this case? Ma'am, did you do it for this case? Like, they're ruthless. You have to protect your own credibility, in my opinion.
Absolutely. So we've established don't backtrack. And then the other major negative on the wife's experts reporting was the comparables. If you're going to compare businesses, you have to show what you're doing is apples to apples. And so he used this broad definition of a mill. And there are many mills in North Carolina, but they don't make the same things. And so the court pointed out that he didn't show that it was actually comparable based on what you would have to look at. And so if you're using comparables, and like you were saying, you have a method for comparables, make sure you can back up your comparables, what you were actually comparing.
Yeah, and this kind of goes back to how everybody says, well, you need to value it in the three ways, right? Income approach, asset approach, and market approach. That's actually not true. You need to consider all three methods and then show why you chose one or two or three of the methods in general. And a lot of people will even put, like an asset approach or let's go with an income approach. They'll be like, well, I did a future earnings and a past earnings, and then I even combine those or average those. That's not really theoretically how you're supposed to look at it. You're supposed to consider these approaches, consider one methodology under each approach, and then say, okay, what do I determine the value is? That's why I think pulling up transactions is always, like, we usually do an income approach, which is, cash is king. What is the cash flow to this company? Then you go over and you say, well, other businesses have sold like this, and it proves up the income approach. You would also use the internal transaction and say, it proves up the internal transaction, because I don't know if they even correlated it back to the internal transaction, but the expert that valued it using the comparative sales said it was like worth 1.8 million, which kind of backs into the value of the 25%, close to the 400,000 or a little bit more than the 400,000.
Well, one thing he did wrong, he divided by 4.
Yeah.
And so to get to the 25% interest, averaging those kinds of things are definitely risky. And so he came up with that valuation, that total value, and merely divided by 4. And that was rejected. That was rejected by the trial court. And then you have to look at the standard of review on appeal. If you win at the trial level, you have a massive advantage on appeal, because it's not whether the appellate court would do the same thing. It's whether the trial court showed an abuse of discretion, which is really difficult to prove. Now, in South Carolina, they describe it, the standard, as de novo with deference to the trial court. And that technically is not the definition of de novo. De novo means no deference, but de novo as an appellate standard of review is for questions of law. And of course, this included more than just law. There was deference to the trial court, and any deference to the trial court means you need to be credible at the trial level. Put all of your effort into your pre-trial business valuation, get that button down, because that's the court you need to convince. Once you try to appeal, it's anything that's discretionary, the trial courts will be affirmed. And so here we had the experts. So we've covered the court critiques of the wife's expert. His comparables weren't comparable. he valued the entire business and then divided by 4, and then the backtracking on the marketability discount. And so the husband's expert, and under the income approach, the initial 25% interest. So the husband's expert valued the 25% interest at $116,000. Now remember, he paid his sister $400,000 for that interest. So the 25% interest was valued at $116,000, and then the marketability discount was applied at 35%, because this was a privately held company with a stock restriction, a really strict stock restriction. And so the stock transfer restriction can only sell to the business itself, other shareholders, or immediate family. Severely restricted the pool of potential buyers, and with fewer potential buyers, the buyers have leverage in negotiating. So that is what supported the husband's expert with these discounts. And that is how the 25% share to the wife, was her half share of 25% ownership, was 75,000 instead of 200,000.
Yeah. And
That's how the numbers work out.
That we would go into the agreements, and depending upon the agreements, that is your largest support for the subjectiveness of these discounts. But also, at the end of the day, even if the nuances are lost on the judge or the experts or are on the clients, at the end of the day, most of the time, an expert can look at this, and if you didn't apply those discounts, it's an immediate red flag. And so a lot of times, even if you get a report from an expert and you're like, it kind of looks right, it's not totally crazy, and you don't understand the nuances, by just spending a few hours with an expert, just say, hey, review this report and just tell me, not as a rebuttal, not as a full rebuttal, but just like, give me some talking points of how it's off. It literally shouldn't take an expert but a few hours to review any report and be like, red flag, red flag, red flag, right? And so I think that that's also what you have to keep in mind as another expert, is that the experts are going to figure it out, right? They're going to have compelling reasons of why you did something incorrectly. And that is part of kind of my typical direct testimony. At the end, I'm going to say, okay, what do you disagree about what the other expert did? And I'm going to be like, categorically, a 25% discount in a privately held company is going our 25% interest is going to have a discount. Like, it makes sense. But we talked about this prior, before we go into the appeal stuff. We talked about this prior, that a lot of people in divorce are like, they get stuck on fair market value being a hypothetical willing buyer, willing seller. And they're like, well, hypothetically, I'm not selling. And you're like, yes. And now in this case, there was transactions that happened within the company. But even then, it's not making the assumption that you're going to sell. It's assuming that if you did sell, somebody would negotiate that price down. Because do I want to go into this crazy family and own 25%? And like, am I getting distributions? Am I getting cash flow? Like, a lot of times there isn't cash flow to a minority holder. So again, how compelling is your testimony? And if I said those things, people would be like, oh, now it makes sense. So it's really, are you selling this to the audience? Are you selling it to eventually the judge in your report? And are you proving it up? Because in my opinion, if you can't prove up any of your position, like lawyer asks you to do something, client asks you to do something, I got to come up with a few solid reasons, or else I just can't do it. Like, I just have to say, sorry, like, think of another route, but this is not the way. And then does it make sense? Like, does this landscaping company, are they worth $10 million, and they're a one-person shop? Like, that's going to lose on logic. And so a lot of times judges are deferring to logic as opposed to what's the strictest valuation theory. And I think that's important as well.
One thing that I'm seeing in other cases, and that's why it's helpful in this format to talk about one case, but in the real world of litigation, you have to look at one case. You can you can reframe your way. Can you do it with multiple cases? So look, broadening out cases we're not talking about right now, but that I've been looking at. It is not great if you present your expert to just poke holes in the other expert. It is not a great strategy for success on appeal if your expert doesn't produce a report, because it's what you're talking about. It means that expert couldn't come up with a better number, so they didn't produce a report and they're just being used to poke holes in the other side. It's not, because the trial court has to, in a divorce, has to value the business and needs reliable and relevant evidence in the record to do that. The trial court cannot make it up. And so if everybody has zero evidence or terrible evidence, the court may order a business appraisal that they both pay for or something. So that's when a court intervenes, if the evidence at the trial level is terrible, insufficient. But if somebody has relevant and reliable, doesn't mean it would be given the most weight, but it can be entered into evidence. It's admissible as evidence. And the other side does nothing or just tries to poke holes at it, that the evidence in the record is probably going to prevail with the trial judge, because that would not be an abuse of discretion. That would be affirmed on appeal. So you just have to understand the mechanics of what the trial court understands its obligation is in a divorce to value assets. It could be the house, it could be the closely held family business, and how that would play out on appeal. Evidence in the record, the trial judge weighs the evidence, determines credibility. That is not going to be disturbed on appeal, because that would not be an abuse of discretion. Mm-hmm. That's why it's so important to get your business valuation expert involved early, but also you need a lawyer. You absolutely need a lawyer who understands how the law looks at these business valuations. And that's really the additional takeaway I'm deriving from what Melissa and I are sharing with all of you. The law is not just law in the abstract. The law actually looks at what's more credible from an expert, given all of the evidence in the record. And so I just shared that having an expert who only pokes holes in the other side is not really a good path for you, if that's the road.
It's not easy to find other state case law, because a lot of these things settle. And so you're not seeing them go through, like they'll settle right at the end. So we don't have any case set precedents, but it's also like you need to do your research, because for this case, it actually did go through the appeal process. And there were some things that the appellate court changed. So let us know some things that they thought that they didn't get right at the trial court level.
Actually, so the intermediate appellate court said, trial judge, you did it wrong. You should not have applied a marketability discount. And what that sounds like is because the wife, just think about it factually, not from the law side, but factually. The appellate court is looking at this wife who only has a half share of 25% of the business. Like, that's not great. And so the intermediate appellate court found a way to boost up her value by saying the trial court should not have used the marketability discount. The South Carolina Supreme Court stepped in and said, we're not going to say you can never use it, trial court, and we're not going to say you have to always use it. We view this as discretionary, and it is appropriate in certain cases based on a proper exercise of trial court discretion. That is the ultimate legal takeaway of Clark as a Supreme Court decision in the state of South Carolina. So it's the South Carolina Supreme Court holding that a marketability discount is available. It's not appropriate in every case, but under the right facts, it is a valid finding to discount a closely held business for marketability purposes. And so given these facts support that, and that's what happened.
Yeah, and they also kind of affirmed the discount for lack of control, like saying that these two, but I think there was one justice that kind of, again, when we say that judges by default are going to go at logic, they're going to look at, again, I think fairness is the F word in court. Like, we're looking at reasonable, we're looking at rational, things like that, like equitable, right? But there was one judge that had a good point, but it was a more of logical point of like, this isn't fair. These discounts aren't really reasonable. So like, what did that justice have to say about some of this and how it, these discounts sort of devalue it for one spouse, even if we logically know that it is a valid theory, right?
Well, there's a very well-reasoned dissent, and that's what you're referring to. So
Yeah.
one justice wrote a very detailed dissent, so agreeing on the marketability discount as a possibility and agreeing that some of the cases cited in the majority opinion applied. But then the fiction of a marketed, so this is the quote. Here, the fiction of a marketability discount is just as apparent, and the rejection of the discount in this case would be no more of a rejection of the principles of fair market value than was our holding in precedent. So basically, the I think you're just gonna have to edit this out. I because I was
Well, I
preparing for
think
all
that
three. I was
I,
preparing for all three cases, so I
yeah,
didn't. The
no,
one thing I would ask you to do is, if we're only going to do one case, let me know, because I studied all three to be ready on
yeah,
all three, and I didn't reread the dissent, so I just don't
no,
have it.
no, this is, they really kind of geared it towards fair value and saying, if you used fair value instead of fair market value, then you wouldn't apply the discounts. And so, it's interesting because, again, when you get a judge that starts to try to figure out this theory, right? The experts should be giving enough information so that the judges are just saying, okay, 25%, 35%, I'm going to go in the middle. But at the end of the day, what they were saying is like, he's going to own 100% of it. And I think that there are other constructs, that are used in other states that talk about value to the holder, fair value versus fair market value. And these are nuances in the valuation community, but there's also logic. And so I think that when you're putting an expert report together, yes, we want to follow the theory. Yes, we want to make sure that we're following the rules of what we do. But at the end of the day, if you don't make it so that somebody could read it and be logical, like, yes, I understand that this person is going to own 100%, but we're valuing a 25% share. And that 25% share doesn't have the same rights to it. Now, could that, and instead of using a 40% discount, I pulled it down a little bit, like,
Well,
how did you
the wife's
incorporate that?
expert
Yeah.
tried to put a 20%, and it ultimately was a 35%, and that's how she ended up with 75,000, and that was a much lower number. And that is what's behind. Courts can look at and that's what happened in the intermediate appellate court, and that's what this dissent is focused on, that we could have achieved a result that was more fair to the wife, even though it's not strictly business. And so the dissenting opinion is talking about would have agreed that the marketability discount, wait, let me get it right. Okay. So the dissenting opinion agreed with the majority at the Supreme Court level that the trial court got it right regarding the minority discount.
Mm-hmm.
Got that right. But the dissenting justice on the Clark Supreme Court decision, he would have affirmed the intermediate appellate court as to the marketability discount, which would have significantly increased the amount paid to the wife.
Right.
And so that's basically what happened. But the dissent was written so that trial courts could read it and see how much more discretion they could have. If the trial court had followed what this dissent has now laid out, that would be affirmed on appeal as a correct application of discretion. And that's why you have to put your effort into the trial court level. You have to know how it works in your state. And that's why you're going to need a business valuation expert early, but you're also going to need legal counsel early. This is not something that a business valuation expert who testifies in multiple states would know particularly about South Carolina.
Yeah.
And maybe even the business valuation experts in South Carolina may not have read the Clark decision. That's the point of this episode, is to give everyone a chance to see the state court system is telling us what is discretionary at the trial level and what is not. And that should inform the process of using a business valuation expert and using your divorce lawyer as a team.
Yeah. And I mean, the real takeaway here is that it's not just enough to have an expert. You can't, it's going to be a he said, she said. The more you do a little bit more research, you have a robust report, you have to be thorough, specific, consistent, don't backtrack. I mean, again, you don't think that anybody's going to figure it out, but we're talking about it, right? And so it's going a lot further than anybody would have expected, but also understanding the methodologies, how you support the discount, in the fundamental agreements and things like that. And it should be known, don't reverse your opinion because somebody told you to.
And then
That's
you have to
probably not going to be
testify
very,
to it.
yeah, right. Don't agree to that. Certainly don't change. And that's why, there's tons of posturing that happens in those discussions at the beginning, right? Like, I have conversations today with people who are getting divorced, and I'm like, hey, this is how high an expert would push it. This is how low an expert would push it. And this is where I think is reasonable, right? Here's foundationally sound values are what an expert needs to push over. And I think you need to be consistent among the cases. I like to say be consistent until you change, and then be consistent with the change that you made of how you look at these things, or how, if you're always doing a 10% discount for lack of marketability, and now all of a sudden you're at 35, the odds are somebody's going to use that against you in some capacity, and they're going to surprise you with it in deposition,
Well, back
right?
up the change. So all of that, and when you make that change as a business valuation expert, back up the change. This is why I used to be forthcoming. I used to do it this way. Now I do it a different way. And here's why. You're fine then. If
Yeah.
you professionally made that change and you're using it consistently with valid methodology and reasoning for it, it's always better to come out ahead. Don't let that be your cross examination, their reveal on cross. You don't let that
Oh,
happen.
and I'm always hoping that people have already clocked out of the listening to this podcast by now, because now I'm going to say something ridiculous. At the end of the day, it's way too obvious to make the changes in the discounts or the cap rate. If you want to make a valid change, you need to make it in the cash flow. Cash flow is always going to be like an average or a weighted average, or like what you expect in the future. It's going to have a whole bunch of factors at play, and it's a little bit harder to understand, right? If you literally change something from 25% to 35%, it's like everybody can figure that out,
Absolutely.
right? And at the end of the day, cash flow is the kingpin here, right? Everybody is just looking at these easy things of like your cap rate. Oh, let's compare those. Let's compare your discounts. Those are easy, low-lying fruit that anybody on the outside can figure out. If you really want to value this properly, I think you have to spend more time in understanding and proving out the cash flow. The rest of it is typically, I mean, there's even some cases that if they show me what their discounts were, if I sort of agree with it, I'm going to go with that. And I haven't released my report. I might be like, you know what? Let's not fight about that one thing, right? Like, that's not the fight isn't in that. The fight is in the cash flow, or proving out that that original value of the purchase would have been the sustainable value. And that's what we talked about, is like, it's almost like they got distracted by these things over here when they could have had a much more sound foundation, instead of just arbitrarily taking discounts on the fact that there was a transaction in this business,
Well,
right?
Melissa,
They
what
could have,
the advice you just gave is so important. Don't fight about everything. Just like don't appeal it, don't attempt to appeal everything. Everything is not an error. So pick your battles. And if, as a business valuation expert, you can agree with the other side, you've just boosted your own credibility. The
yeah.
judge will look at you as, oh, this person's being reasonable. And then you have even more leverage for the true crux of your opinion and what your side needs.
Yeah. I mean, I even go so far as to ask the other expert, and of course I'm talking to the lawyers too, but I'm like, hey, before any of us puts this in writing, right? Before we exchange reports, like, can the experts just chat? Can the experts talk? Because sometimes it's really the lawyers and the clients are positioning, and they're advocating, and that's their role. But as experts, we're really to educate the trier of fact. We're here to educate the judge or the jury on what the financial reality is. And so half the time I'm like, hey, if I can talk to, and again, it's probably somebody I know. Hey, where are you on this? Because are we vastly off, or are we closer than we could think? Sometimes we can even mediate the valuation issue and say, hey, guess what? This is something, not always, and not every expert is going to agree to talk to me, because they probably shouldn't. No, just kidding. But I think that it's rational. Like, oh, you're at a 10% discount and I was at a 12%. Okay, let's just agree that 11%. Like, let's take that off the table of a discussion. But again, what I'm typically talking to them about is, how did you get to your cash flow? Like, are we fundamentally understanding the cash flow that's expected in this business? Because if you value the cash flow, the cap rate is the risk that the cash flow continues. So the more sure you are about any of these things, you don't need the discount to come into play. Like, if I had shown when they bought it from the sister and how the cash flow was different now, I could have shown how the value would also have been different. And that would have proved out my position that the value is lower because the cash flow was lower than when he purchased it from the sister, right? Like, those things I think are in play, that you're proving it out in different layers in the actual valuation as well. But again, I don't like to go to trial and even blink an eye or be stressed about my testimony. I like to go in pretty solid and be like, listen, the value is the value. I'm sticking to the value. Please, judge, do not average this. Choose my value.
Well, mathematically, averages really, in different contexts, averaging is not allowed, but a judge can pick a number. So let's say the experts, I don't know if you can say experts are like this. If the judge picks a number anywhere in between, that is just a proper exercise of discretion, whereas averaging, which is not mathematically correct, is usually reversed on appeal in many instances, not just businesses, other assets. And I have those litigated cases. But the other thing I want to sort of interject is, divorce business valuation is different from business valuation. It's different. All of the guidance for the trial court, and then what the appellate court is doing, it's because it's a marital interest in the business. That's not the same thing as actually valuing and selling a business. And so keep that in mind also, that you can value businesses for all kinds of purposes and all different types of litigated claims, but divorce is different, and you really need to be working with the divorce lawyer sooner so that you are in line with how it's different in divorce litigation of business valuation.
Yeah. I mean, my big soapbox is, I hope in the future that we'll have consistent state methodology for some of these things. But right now it's on a state by state basis. So I'm actually surprised that South Carolina got it right, because they are a little antiquated in some of their other laws around valuation and complex financial matters. But kudos to them this time. So we appreciate you, Kelly. And I want to just have you speak briefly, because you also have a podcast called Wealth Litigated. And maybe you could just tell us a little bit more about, like, why somebody would reach out to you or to be on your podcast, or the things that you're focused on right now, to give us a little bit of an idea of, a little insight into Kelly and why she's so brilliant about these cases.
I'm so excited about Wealth Litigated as a podcast because it lets me expand my range in assets. So I started with wealth dispute resolution, legal scholarship in 2007. And all of the cases I curated over the many years I've been doing this, I focused on real property, mortgage, secured debt, but all of those cases had other assets involved. And then the intersection of multiple areas of the law. So asset valuation and division in divorce, but also estates, trust contest, probate litigation, all of those things with family wealth disputes. And that's where Wealth Litigated Podcast comes in. I do a deep dive on one case at a time with takeaways that you can implement for your business and your clients. I want you to learn what went wrong, not live what went wrong. And so basically, we're showing what worked, we're showing what didn't work, so you and your clients can get it right.
Yeah, and she has curated these cases that we're going to continue talking about, and she is just brilliant. Like, these are cases that, again, are not as easy to find as a valuation expert. And I think that we have to learn in this manner. You know, like some of these things we're like, okay, yeah, of course I know that. But again, these cases are still happening. So obviously people don't know that. And they're putting themselves out there in positions that are not going to be beneficial in the future. So if you want a long standing testifying career, you know, protect yourself and put things in place. Again, my review process, I do this pretty continuously. Like, I never release a report. And even when I'm going to, I'm like, hey guys, this is going to be used against us in the future. So if anything wants to change, I'm probably not going to want to change it. Okay. So if you think anything, if you think we're going to get another 6 months in and want to look at the new value, because we just did one recently where we looked at the value as of 24, and it was great. Like, I mean, it really is a fine value, not doing anything, no arbitrary looking at it. It just on its face, the reality is the value is a reasonable value for us to make an offer on. And I said, listen, we should just update it and make sure that 2025, because what you don't want to do is make an offer on some old numbers and then the new numbers shift the whole valuation. Like, let's just get those, like, wait another month, get those finalized. Let's incorporate it. Let's see what implication they have, and then finalize it at that stage. At all times, we are the experts. We are the consultants. We need to guide them in how they should operate, not just be like, oh, you're the lawyer. Oh, you're the client. No, this isn't the customer is always right. This is, I am the consultant to tell you how to not ruin your case. If I go up on the stand and I fumble, it means the whole case fumbles. And you know, like, I never say that I can win a case. I think that that's all, you know, like legal advocating and positioning and all of that. But I can definitely lose a case for you. And so if you don't take that ownership over it and really educate them on things that matter and things that, you know, like I tell my clients, don't send me an email that's like, hey, Melissa, make the value this. Like,
Don't.
it's not going to be helpful in the long scheme of things. Even if
you want to make sure you've been retained by the lawyer, and even then that's not bulletproof. But yes, you want to make sure there's some privilege attached to those kinds of communications.
Yeah, I love it. All right, Kelly. Well, we have other cases that we're going to talk about in the future, but this one was a great one, and we will see you soon.
Thank you.